G'day, Nina. How are you?
Good, thanks, Andrew.
We got a bit distracted with another discussion, didn't we?
We got way too into the material.
Well, we worried there wouldn't be enough things to talk about.
I know, the tide's turning.
It has. The last two breakfasts have been
Very action.
very action-packed.
We're running out of time.
For that, I think we might just jump straight in. I think casuals being terminated.
Yeah, this is a funny case. So I think it's a very common situation. This was a casual who took a period of unpaid sick leave for mental health issues. The employer wasn't very happy about that and reduced their hours to 0. The casual then brought a general protections claim and the employer said, no, we didn't dismiss them.
Just step back a little bit though, because it misses the level of contention and bad behaviour where the employer fabricated a whole lot of arguments before they went in there, which were utterly unbelievable as well. I think you should add that in, because this is a case about the Fair Work Commission bending over backwards to give a smack in the chops to the employer to allow an employee's claim to proceed to the federal court. That's really it, isn't it?
Yeah, pretty much. Like, I think they really attacked his mental health, said, because of your up and down moods, we just can't deal with you anymore.
Yeah.
Though they lied about that when it was put to them and said, no, of course, we never said that.
So the case decided that reducing casual to 0 is dismissal for the purpose of general protections.
Because they were using that as an excuse. It's not saying that you can't reduce casual hours to 0 and that's automatically all.
Yes, that's right. Yeah. So there's not a lot of law in this case, and I guess what Nina and I raised this case is because we don't want anyone going out thinking this is a precedent. No. But what it does say is if you reduce someone's hours because of a workplace right to person exercise. So Nina raises me, it's not safe to come to work on a Monday here because it's noisy, and I go, all right, don't come to work on Monday, full stop.
Yeah, we'll just give you 0 hours. That is definitely a dismissal.
Okay. Yeah. And it doesn't matter whether it's a dismissal for general protections. It's treating someone adversely as a result of a workplace right. So again, the case is a bit of a nonsense in a whole lot of ways, because it doesn't matter if it was a dismissal or not, the person still would have had an entitlement to bring an adverse action.
Yeah.
But I know it's out there being spoken about in workplace land, saying very important case. It's absolute bullshit. That's what the case is. So let's move on to the next one.
Oh, gosh.
All right.
Okay. So
this is our biggest case, isn't it, today?
I definitely say so. I think the facts aren't super interesting, but essentially it was an employee in a social services business who had a phone while she's on call during the holiday period. When she came back to work after the period, she deleted all the stuff on the phone, which was a breach of their policy because they said, it could contain client information. And she said, look, there was no client information on there. I was just deleting my messages and things like that. And during the investigation, they didn't really look too closely about what she said. They said, look, it's a breach of our policy.
I think it's very important during investigation, they didn't find whether the phone had or did not have.
Yeah, there was no evidence of it at all. And they could have done like the forensic analysis but they didn't. But most importantly in this case, she said she wasn't aware of any clause in her employment contract that said there was an obligation to keep client information, and she had no idea or did not understand the policy at all because no one had ever taken her through it.
Now let's stop a minute and consider the policy, which was described as being overly legalistic and complex.
Yeah, a lot of legal jargon in there and IT jargon and things like that.
I think one of the very first articles I wrote was called "Paper, Paper, Paper. When will the policy stop?" Something like that. But it's this whole idea that people think you can protect a business by having a wad of documents that describes in very technical detail.
Yeah.
What people can and can't do. If a person can't read and understand something, it's not enforceable. Can I just make that really clear? Because the art of a direction is not only must it be lawful, but it must be reasonable. And to be reasonable, the person has to understand and be able to be competent in it.
Yeah.
So if I get a consultant to come in to build my policies and procedures, or worse still, lawyers, and I produce policies and procedures which are incomprehensible to anybody, which we see, by the way, daily.
Yeah, all the time.
If you have those things, they offer you no protection. And I think, as Nina said, as she was walking into work today, she keeps laughing about it because she's seen so often policies like that condoned in the breach because nobody knows them, including HR.
Including HR. Yeah, that's the crazy thing. And that no one's trained in it and they've just turned a blind eye and we'll say, what's your policy on this? And they're like, oh, Oh yeah, here I've dug one up.
And so what happens is Nina does something I don't like, and I go down in my bottom drawer, and with two hands because they're very heavy, I pull out all the policies and procedure, brush the dust off, and go, now how can I get Nina? Ha ha! Yeah. And then I do an investigation that doesn't investigate the relevant facts, because the laugh about this case is she didn't not comply with the policy or a contract, because there is no evidence that she removed client records. Yeah. So can you just see what I mean, this is a well-meaning organisation who technically tried to do the right thing, and this is a well-meaning person who tried to do the right thing with a completely flawed policy and investigative process and disciplinary process. So in a lot of ways, it's an incredibly sad process, because I'm quite sure both the organisation and the person were good people trying to do the right thing, but they went to those dark policies.
Yeah, it's a crazy thing, because in the decision itself, they said, look, if it's a breach of a policy, that is a valid reason for termination. But the whole thing was just harsh because, like you said, there was no evidence. And even if it was, like, the actual consequence was minimal. So,
yeah. Okay, well, look, let's go to an anti-vax case.
Your favourite.
Well, this again is a case that's hardly worth mentioning. I think the importance of this case is really that the person who had medical contraindications to AstraZeneca raised that as an issue and then failed to provide further medical information suggests that they were unable to take any further vaccination during the mandated vax period.
Mm-hmm. And then got terminated.
There was a mistake made by the Commissioner at first instance around a certain set of facts around long service leave. Yeah. The person went through a convoluted process of appeal, eventually got to the full bench, and the full bench sort of looked sideways and said, but you didn't produce any evidence during a mandatory vaccination period of your inability to take other vaccines.
Which means the decision wasn't wrong. Like, picking up a tiny technical error that there was incorrect facts, they just rectified that and said, that's it.
Yeah, again, really a decision we just put in there for fun. I think what is exciting and coming up though, Nina, is the FSU, the Financial Sector Union, a union without a meaning, only has 4 basic clients, the 4 banks. Nonetheless, the FSU is bringing a case against NAB around psychological hazards from excessive work.
Mm-hmm. Against managers.
Yeah. Interesting case. Can I just stop for a second and say nearly the whole of the professional services sector is at risk from this case.
Yeah.
When you look at law firms, we constantly work outside of 40 hours. When you look at
IT professionals, things like that.
So this is a case actually that can have a lot, very, very significant, very, very significant output. And the most important part about it is, I think Nina and I have now been saying for 6 months that psychological hazards is the doorway through for excessive hours. And you might like to take over from there what the FSU was saying.
Yeah, so in this case, they've brought it on behalf of middle level management. So I believe NAB is covered under an enterprise agreement, and for lower leveled employees, any additional hours is paid as overtime. But for this level of management, they're paid a higher salary, and the expectation is they just work reasonable additional hours, which could be like, 10 to 16 hours a day, or working on the weekend as well. And their FSU has said, look, that's not enough, and it's actually unreasonable the amount that they're expected to work. It's a psychological hazard because it's higher job demands, and the reason this has come about is because NAB has poor resourcing and is just having, instead of filling roles, they're having people take on other people's duties. And so it's really only just been lodged, so it's really interesting to see where it goes. But I think, it has huge ramifications. Like, we're already seeing this in the education industry with the unions trying to use this as an example to step the foot through the door. It hasn't succeeded thus far, but if the FSU succeeds in this, you're going to see claims against pretty much any company, because everyone has these set off higher award salaries, which set off everything. So
and look, you see it classically in education in outward bound activities.
Yeah.
But we are seeing greater attacks and
on teachers as well.
Yeah, what we are definitely going to see is psychological hazards used as an indicia for saying what are reasonable additional hours, and that phrase has enjoyed a legal understanding. it's sort of a process where Nina and I can say, look, in this industry, reasonable additional hours would be between 4 to 6 a week because the cases sit around that.
Yeah.
This is eroding that understanding of what existed before. So it's a real watch this space sort of case.
Yeah, because Andrew, I don't think it's actually been tested before. We've talked about reasonable hours in terms of, someone's capacity to do it if they have weekends, but no one has actually tested it as in the psychological effects on someone.
No, they haven't. All right, very quickly, we're still going on cases. Look at this. Negotiated exit case. This is Jerush and Leaper. Interesting case. Every day, somebody realises that they're not getting on with their employee and realises it's not a quite perfect fit, and they decide to have this informal conversation. Now, remember, we're talking about conversations with people who are captured under the unfair dismissal regime here, not the high earning, above the high earning threshold. Because for those people, if you're not happy with them, you just give them notice.
Yeah.
Okay. But
I'll put them on gardening leave.
Really, I think this has educated most of my children, this particular case, which is where someone goes, look, Nina, it's not quite working out. Can we reach an agreement about your departure, which is respectful for you? And then he goes, didn't know I was underperforming.
Well, in this case, they did. They had 2 meetings beforehand, but she thought she was improving.
That's right.
Yeah.
Whatever it is, Nina's not going to be happy with the conversation that lands. And in this case, the putative Nina was not happy with the conversation and brought an adverse action. But the person who was negotiating, the CEO, thought that everything had gone well.
Yeah, because it went all the way to the
produced
last
the deed,
stage. Yeah.
And then the woman
signed off on the reference, she signed off on the communications to everyone, and basically it was almost signed, sealed, and delivered. And then 2 days after agreeing to everything, she was like, "No, I'm not going to sign the deed."
Yeah, and brought an adverse action claim. So can I just say to you, Nina and I have different views about this, so we're going to share our different views. My view is if someone's within the unfair dismissal regime, deal with them in the process that's meant to happen under there, terminate them, and then you can offer a deed and a respectful departure after that with relevant communications. Because Nina's view is, well, look, you can judge when it's going to work.
Yeah, so I agree with Andrew that there is a huge risk, but I believe that there are some circumstances when you've known the person very well, you've had the conversation, and you can see that, look, they want the resignation more than you do. In those rare circumstances, and I stress rare, you can offer and have that discussion for a deed. We always say have the discussion first and feel them out for offering it. And in that case, when there's little risk,
so that discussion
before termination.
That discussion would really look like this. Nina, how do you think things are going? And Nina would go, what do you mean? And I go, well, do you think you're getting where you need to get? Do you think it's working? And then he goes, no. Go, okay, well, look, how can we work together?
Yeah, how do we
do this in a way that's respectful? Because I think we agree with you. Okay? That's a time where you can say, well, look, let's organise a departure, communication, you can do all those sort of things. But the answer is it's under a legislative regime. The legislative regime requires you to do certain things. So my view is, except in circumstances where you have that level of confidence, and even then there's high risk, what's wrong with going along the termination path and me having the conversation with Nina and offering a support person saying, look, objectively, this is where we're up to. This is the stuff we've talked about before. You've had one warning around this. We've explained it needs to improve. It hasn't improved. Our view is it's not going to improve. And on that basis, we're going to terminate your employment, but we'll pay you out notice. Then he goes, I'm not very happy with you. I go, good. Okay, good. Well, look, we are happy to try and manage this in a way that looks after your future as well. We're happy to provide that bit of extra money, longer notice payment, whatever it is, and we'll give you a deed, and the deed provides us with a level of protection, but that also fixes the communication that we have between us afterwards.
Yeah.
I'd prefer that way. But there are times, just remember, if you're dodging the hard conversation, know you're doing it. That's all I'm saying.
Yeah.
If it's something that's working for the mutual benefit of both of you, do it.
I agree with that.
But if you're dodging the hard conversation, know you're doing it and you're just creating risk.
Yeah, because, and also, even if the employee doesn't sign the deed, you've kind of played your hand. And then if they bring a claim, they're going to expect that minimum level in any kind of negotiation. So it's kind of a lose-lose situation.
It is. All right, let's go on to our topic for today, which is the reckless director. I've got a case for you today, which is sort of one of those cases that you just read about, and it's one that you sort of go...
You've had a lot of joy with this case.
Well, not so much joy. This is... that. we're not going to talk about the liquidated company, are we? No, we're going to talk about the reckless director. Yeah, we'll run out of time for that one. It's gone. This is a case called Cordell. And Brian Cordell was one of 6 directors and was the operational director within the organisation. They were sand miners. Part of sand mining is you have pressurised hoses that wash the sand.
Yeah.
In this case, the hose, which sat about 4.5 metres above the ground, had a valve and the valve broke. And Brian Cordell, to fix the valve, decided he would use some earth-moving equipment, some front-end loaders, and stick 2 people in the front-end loaders up to 4.5 metres to actually fix the valve. Now, this is something with a bucket, and you put 2 people in a bucket.
Yep.
For those 2 people to communicate, they had to communicate to someone over here to talk to the driver there to actually say how to lift it and move it. That's just as a start. Now, Brian Cordell went home and thought about this and then came back the next day.
This was his bright idea.
This was the cunning plan. His policies and procedures said he had to use mobile scaffolding or scaffold.
And a harness.
Yeah. And there was no harness involved with this. What happened, it was inevitable. For some reason, the bucket tilted slightly. One young boy jumped off to safety. The other guy became entrapped and his head was wedged, causing 160 sutures in it and significant ugly after things which caused him psychological harm. And what the judge said, finding him and the company reckless, was this. He said, you got a policy and procedure that adopts industry standard. Mm-hmm. You went home and thought about this. This isn't something a spur of the moment. And it's not something you haven't done before. You've used this type of behaviour in the past. So you've got an utter disregard for the risk of serious injury, which is reckless endangerment.
Yep.
And gave him a 6-month sentence in jail and suspended it. Okay. Had he had a prior offence, he would have definitely gone to jail. Okay.
Oh, yeah.
But my point about this case was this guy raised the argument the company can't be liable because it was his mistake, which misunderstands attribution.
And it literally, that's literally what the statute says.
That is what the statute says. So it was a dumb argument. But the court couldn't get past the fact that a person who in a premeditated way ignores his own policies and procedures that adopt an industry standard. It's actually a very beautiful judgment. It goes through and does.
Yeah, it's very detailed.
Reasonable practicability, and it says, look, here's a hazard that's known. It's an obvious hazard that's known. Here is the level of risk. It's high. Here is the control that's recognised. In fact, your policies and procedures define reasonable practicability. It is the correct method of dealing with it.
Yep.
And you ignore it. So you breach your due diligence obligation. So you've got the primary breach duties done.
Yep.
And goes on to say, well, but not only did you do that, but you were so careless. You just weren't interested at all in what was reasonably practical. You chose to do something knowing it was dangerous.
Yeah.
So had this boy been killed, it would have been industrial manslaughter because it has all the smell of that utter indifference.
Yeah, and complete negligence too. Yeah.
So pretty interesting stuff. And when we look at what's happening with the harmonising of law now, where we are going to have industrial manslaughter in all jurisdictions, where negligence is going to become part of recklessness, and where in all jurisdictions very shortly all insurances are gone. This is the sort of case which will percolate well beyond reckless endangerment in the future if there is a death.
Yeah, and I think the important thing from this is, Andrew, it's not that uncommon. Like, yes, the slight facts might change, but this kind of situation is happening in businesses, particularly smaller family-owned businesses, every day because they're prioritising operations over safety, even though they're well aware of the risks and they have clear policies that say they, need to step up their game.
Yeah, and look, that's the reason we talked about it. That's the reason we chose it as the main theme today. It is a constant theme that comes in front of us where people have decided to do something to get the job done.
Yeah.
And it's often in a family business, it's the owner of the business who says, look, just get on with it, just get the job done. But we also see it in very large scale businesses where there is a cost, where there's money burning and someone says, look, can you just cut through this and just go and get it done?
But the costs, I think for this, you said it was like $4,000.
$4,400
to get it done safely.
Yeah. Yeah.
That's the cost of that person's injuries, I guess. Gosh.
So there you go. All right, we're going to give this a bit of a run now, and we're going to go off the case study where we'll revisit this problem again.
So Ken was the head of operations for Love the Load, LTL, a heavy earth-moving contractor. LTL had operations throughout Australia and supported major builders at its Brisbane port site, the largest non-mining excavation in Australia. The EPA had stopped work at the site because of high chrome, mercury and asbestos levels in excavated soil near the old foundry in February 2023. The delays in excavation were leading to delay costs on LTL. Ken flew up from Sydney to reduce the damages risk. When he arrived on site, he noticed a major area of excavation had not commenced. He asked his site foreman why. The foreman explained the road to the site needed fresh rolling and grading and that cement culverts needed to be installed beside a bridge to manage water flow in the event of heavy rains. Ken looked up into the sky, said to the foreman, "There's no rain today." Looked over at the large mobile crane and asked why we couldn't use it to move the culverts. The foreman said the weight was within the crane, but the road meant lateral movement would make it unsafe. Ken and the foreman drove down the road to the excavation site. It was bumpy, but not too bad. Ken instructed the foreman to have the crane move the culverts in place and start rolling and grading. The foreman again raised the weight issue, so Ken said, "Let's get one up and see what the controls say." The culvert was lifted and the crane dial showed it was 85% of load. Ken told them to get a move on. He walked with the crane on the way down to the bridge. Several times along the way, the crane alarm system beeped, suggesting the movement of the culvert overloaded the crane. Nonetheless, the crane successfully moved the culvert into place. Ken directed them to do the next one, and part of the way down to the bridge for the next concrete culvert, the crane lurched sideways and fell, crushing the foreman and dogman who accompanied it.
All right. So, not unfamiliar set of facts.
No.
RV what?
Yeah.
Canberra Hospital. So the company had detailed policies and procedures which, if followed by Ken, would have prevented the incident. The foreman tried to enforce these policies and procedures. Can the company still be liable under safety law?
Yes, because the policies are evidence that they knew what was reasonably practical.
Well, it's interesting. If the company had repeatedly done the right thing beforehand and the actions of Ken were so outside of what had occurred, there is an argument that only Ken could be liable.
But if Ken's liable, isn't the company liable for attribution?
Well, no, attribution only works to the extent you can carve out attribution if you can demonstrate everybody else was competent and the business is competent. The difficulty here is that Ken is an officer, so Ken is the company.
Yeah. And also, like, the company is definitely the one who's done the behaviour. Like, Ken's directed them to, but the other,
Yeah, they tried to resist. I'm just saying, so...
I feel like that would be very difficult to run.
Yeah, well, there's been cases that have been successfully run, not where it was an officer, but where it was an employee. You did something...
I feel like that makes sense.
And I guess that's the point of this question, is to show when it is actually the officer who does it, which is the mind of the corporation.
Yeah.
At that stage, then the company is most definitely liable.
Yeah, because if it was like a random employee, you could say they were an outlier.
That's right.
But
this is the only mind. So anyway, look, both of them would be liable under attribution. So the next question is, Ken is an officer of LTL. Is he in breach of his due diligence obligations? Now, the answer is pretty easy, yes, isn't it?
Because he knew of the risk.
I understand that. But let's talk about what it is. I just want to be clear about what his due diligence obligation. So was Ken aware of the high risk involved in it?
Yes.
Yes, he was.
They told him about it.
Not only did they tell him, so in Victoria, he was on liability under 144 because he'd been told, and he had the power to influence and control it. So he's definitely liable under 144 in Victoria. In every other jurisdiction, he had the objective knowledge of the nature of risk that he was directing to be undertaken. He had a knowledge of the law, or ought to have had a knowledge of the law that applied to it, and he ought to have known what are the resources that ought to have been applied to doing it.
Yep.
And he knew there was a system and he should have followed it.
Yeah.
Okay, so he's definitely in breach of the due diligence obligation.
Yep.
So, is Ken guilty of a Category 1 reckless endangerment?
Yes, because he engaged in reckless conduct that put someone at serious risk of injury or death.
Okay, and the reckless, when we talk about that, so...
He was indifferent to the risk.
He was indifferent to the nature of the risk. So, in fact, how indifferent can you be when you hear the beeping of a crane going? And this is what this is Queen versus Watt, the industrial manslaughter case was about, where a crane went down a track. It was overloading and it was actually sending alarm signals as it was going. And it had happened in the past. They'd used this crane in the past in the same way. And Watt was charged with industrial manslaughter because it eventually fell and caused death. So, yes. Okay, next.
But it's not just the beeping. Like, the foreman raises that, look, these are the risks and you can't do it, it's unstable. So it's many different layers of being
so many
aware of
different,
the risk. Yeah.
Is Ken guilty of industrial manslaughter?
So it need to be negligent, breach of duty.
And such a wanting of standard of care.
Yeah.
So what we've got to look at is a high degree of negligence and a complete want of standard of care. And if we go back to the basic standard of care.
That results in death,
Yeah. So what is that? Is there a hazard? Yeah. There's a multitude of hazards.
And they're high risk.
And they're all exceptionally high risk. Mm-hmm. He was put on notice of the risk actually while it was happening.
Yep.
So if he wasn't aware of the risk during the time, at the time of decision making, he was at the time it was occurring and could have stopped it.
Yep.
What was the control in place? To stop. The only control was not to proceed. Okay. It was the only elimination strategy that had to work. He didn't do that, and he had the resources. He had the power to do that. So it was so wanting in that reasonable practicability.
Does the fact that he got them to kind of like test it, like?
But the test actually gave greater knowledge of the risk that was involved because it actually had the beeping.
Oh, it's the beeping, but as in the fact that it didn't fall, doesn't in itself like mitigate.
No. In fact, the fact doesn't fall. There's just
luck.
Good luck is the short answer.
Yeah.
It could have broken. The crane could have collapsed. A whole lot of things could have happened. So he's in the gun for industrial manslaughter. All right. If the company had a prior conviction for a safety system breach around crane usage, and Ken was the head of operations at the time, would this increase the likelihood of a custodial sentence for Ken and heighten the penalty for LTL? And the answer is yes. And I guess this is something that Nina and I constantly advise people about. When you look at breaches of safety, the bottom three breaches of duties, the bottom duties are safe plant or site, safe supervision, and supervision is the third. All of those don't create a lot of officer liability, but when you move up to a breach of a system, and particularly where the system breach is one which is controlled by the relevant officer, and then there is another systems breach, particularly if it is the same system, but another systems breach. Well, here in this question, it's about crane usage.
Yeah.
That's a definite go to jail.
Yeah.
Because what's happening at the moment is, with no prior convictions, people's convictions are regularly being suspended on a good behaviour. But the answer is, if you've got a prior, even though you're not personally charged, it's a relevant prior to your state of knowledge.
Yep.
On that basis, I reckon Ken will be off to jail for 6 months.
Yeah, they have to. It's got to be for deterrence reasons.
Yeah. Now, will LTL be guilty of the same offence as Ken? In other words, if Ken is guilty of industrial manslaughter, could LTL be guilty of a lesser?
No, I think because he's an officer, it's directly attributable.
Yeah. Well, I think it's slightly more difficult than that, but I agree with you because he is the active mind of the business. Yeah. So he has a capacity to influence.
Yep.
He has the financial control, the ability to control what needs to be done. And he has the state of knowledge of risk. Yep. I think under those circumstances, they are the state of knowledge of the company. When you look at what the company does, it's actually got all the infrastructure that talks about that knowledge.
Yep. And it ignored it.
Yeah, so he's acting as the company when he does it because of an officer. So the short answer is they'd both be guilty of industrial manslaughter. So that's the reason I wanted to do this case today. We don't often do just a safety case.
No, but I think it's good because it clearly shows step by step exactly how easy it is to breach.
Yep.
And there's a common misconception that officers can be like, no, look, this is my bad decision, separate to the company, but it's very closely intertwined.
Yeah, and that's what Cordell's case talks about.
Yeah.
It talks directly about where you can't actually separate the actions of Cordell from the Cordell company, because actually he is the mind of Cordell company and he was the person who gave the directions in breach of their own structures and strategy.
Yep.
Okay. Yep. So look, that's it for today. Yeah. Interesting set of cases. There's some really interesting stuff happening in the next week too. So.
And Matt will be back.
Matt will be back.
Mm.
That's exciting. It's exciting for all of us. We can actually stop sweating so profusely and working so hard and waiting for the NSU to attack us. All right, guys.
Give us a thumbs up.
See you later. Bye-bye.
Bye.